Hi and welcome to SQE Success, your pathway to becoming an English solicitor. In this video, we'll explore 3 scenarios involving easement and repair responsibility, a key topic in land law under FLK2. Let's dive in. A landowner with freehold title grants, by deed, a right-of-way over a shared gravel driveway to a neighboring freehold owner. The right-of-way is granted in return for a one-off payment. The deed does not mention maintenance or repair responsibilities. Several years later, the driveway deteriorates and becomes difficult to use. The dominant landowner wants to have it repaired and asks whether the servient landowner is liable for any of the cost. Who is legally responsible for the repair and maintenance of the driveway in this scenario? A. The dominant landowner. B. The servient landowner. C. Both dominant and servient landowners equally. D. The dominant landowner has the right to repair the driveway but will bear the whole cost himself. E. The dominant landowner has the right to repair the driveway and may seek contribution from the servient landowner. The best answer is D. The dominant landowner has the right to repair the driveway but will bear the whole cost himself. Where an easement, such as a right-of-way, is granted and the deed is silent on repair obligations, the common law position set out in Jones against Pritchard, 1908, applies. The servient landowner is generally not under any obligation to maintain or repair the route. The dominant landowner has a right to carry out reasonable repairs to enable proper use of the easement. But he must bear the cost himself. The dominant owner cannot force the servient owner to contribute, nor can the dominant owner claim a contribution unless contractually agreed. Scenario 2. A deed of easement was executed 5 years ago, granting the dominant landowner a right-of-way over the servient landowner's private driveway. The deed includes a clause stating that the dominant and servient landowners shall contribute equally to the reasonable costs of maintaining and repairing the driveway. The driveway has now deteriorated, and the servient landowner arranges for repairs, costing £4,000. The dominant landowner refuses to contribute, arguing that the repairs were carried out without consultation and that he is not legally obliged to pay. Which of the following best describes the legal position? A. The dominant landowner has no legal obligation to contribute because he was not consulted. B. The dominant landowner must contribute £2,000, as expressly agreed in the deed. C. The servient landowner must pay the full cost because he initiated the repairs. D. Only the dominant landowner is liable if the repairs were essential for safety. E. The clause is unenforceable because easements cannot impose positive obligations on dominant owners. The best answer is B. The dominant landowner must contribute £2,000, as expressly agreed in the deed. Where a deed of easement contains an express clause requiring both parties to share maintenance or repair costs, that clause creates a contractual obligation. The dominant landowner cannot avoid payment simply because he was not consulted, is bound by the terms of the deed, provided the repairs were reasonable, may challenge the reasonableness of the cost, but not the existence of the obligation. If the servient landowner acted reasonably, the dominant owner is liable for his share. Here, £2,000. Scenario 3. A property owner, A, has openly used a private pathway across a neighboring owner's land, B, for access to A's garage for over 25 years. B has never objected to A's use of the path. No written document or deed of easement exists. The path has now become severely overgrown and uneven, and A wants to resurface it. A also demands that B contribute to the cost of the works, arguing that the path is on B's land. Which of the following best reflects the legal position? A has a legal easement and can compel B to contribute to the cost of repairs. B has no easement because the right-of-way was never recorded or granted by deed. B should pay the cost of repairs. C has a prescriptive easement and may repair the path, but must bear the full cost alone. D and B are jointly liable to maintain the path under common law. A's easement is implied from long use and must repair the path and bear the full cost alone. The best answer is C. A has a prescriptive easement and may repair the path, but must bear the full cost alone. A has acquired a prescriptive easement through long use as of right, i.e. without force, secrecy, or permission, for over 20 years. This is recognized under Common Law and Prescription Act 1832. A is therefore entitled to continue using the path and to make reasonable repairs to keep it usable for the type of use established. However, prescriptive easements do not impose positive obligations on the servient landowner, B. A may not compel B to pay or contribute to the cost, unless such a duty were expressly agreed in a deed, which doesn't exist here. This table shows who is responsible for repairing a path or driveway under different types of easements. In Scenario 1, if the right-of-way was granted by deed but the deed is silent on repairs, the dominant owner, the one using the path, can fix it but must pay the full cost. The servient owner, the landowner, has no duty to help. In Scenario 2, if the deed clearly says both owners must share the repair costs, then they must each pay their agreed share, as long as the work was reasonable. In Scenario 3, if the right-of-way comes from long-term use, over 20 years, the dominant owner can repair it to keep using it but must pay all the costs alone. The servient owner has no legal duty to contribute. Have you noticed how a slight change of fact can affect the legal outcome? That's exactly the skill the SQE tests, and mastering it is key to exam success. I published books filled with MCQs, each built with 3 variations of a legal scenario to sharpen your analysis and deepen your understanding. It is a must-read to pass SQE 1. Turn your ambition into qualification. Begin your SQE journey to become an English solicitor.